everybody. Happy Sunday. Welcome back. I hope you guys are all having a fantastic fall morning. Now, guys, just let's get it out of the way. I know there's football, but we got an hour before any of the games that matter start, right? Jaguars, Rams, come on. Anybody really care about that game? I'm just saying it how I see it, guys. So we got an hour to hang out. We're going to look at this gag order. We're going to be talking about gag orders today because this is a rabbit hole I have really gone way, way, way deep down in the last couple weeks or so. Just really gotten into this whole First Amendment versus the courts intersection. Because what I found, and this, I don't know, may come as a surprise to you or may not, when it comes to cases that involve criticizing, the mayor, the president, the executives, the court's very, very happy to speak broadly of the importance of the press and what a critical role it plays in our system of government and our democracy. But boy, then when it comes to criticizing the courts, and the court processes, then you get a little bit of a different tune sometimes. We have a little bit of chaos this morning. Just gonna put that out there. The cats are going wild. The dog is going wild. I don't know what you're going to be able to hear or not hear. They are likely going to pop up. Hopefully there won't be too many claws involved. But just to give you guys a fair warning that, yeah, the cats are around. So gag orders, it's like you don't have a high profile case anymore without having a gag order. It's just almost become routine. And as we're going to see as we look at this particular one, it's like they don't even really give any thought to doing it or why they need to do it, what the justification is, and what the supposed requirements are supposed to be able to enter one. But at the same time, we're not, in this particular case, the prosecution of Tyler Robinson, we're not seeing the press coming in and challenging this, going wild, like they did in Koberger. I'm going to have to start removing cats here. Or they're going to be climbing all over my keyboard. Look at that long cat. Look how long that cat is. My goodness. Hi, sweetie. This is going to be kind of a constant battle. So we're not seeing a lot of interest from the press in taking this particular gag order on, which is a little bit surprising to me, both just in terms of the role that you conventionally have played in protecting the First Amendment rights of the public, the profile that this case has, the huge case, a lot of interest in it, a lot of questions about it. And then finally, the legal posture in this particular jurisdiction, which is what we're going to talk about. And we'll probably get there right about the time, that football is starting. And so, those of you that are crazy people more interested in football than case law, well, we all have our interests. But you case law fanatics, you can hang out with me because we got a couple that we're going to look at here so that I can show you. It's just a little bit odd to me that we're not seeing a little bit more protesting about this particular order than we are. So let's go ahead and start by taking a look at the order itself. So here we go. 4th Judicial District Court, Utah County, State of Utah, State versus Tyler Robinson. This is the protection order regarding pretrial and trial publicity. So we have the defendant, Tyler James Robinson, is charged with 1 count of aggravated murder and other felonies. These are like the predicate findings that are going into the order. The case has generated and is likely to continue to generate significant pretrial and trial publicity. That publicity can compromise defendant Tyler James Robinson's right to due process of law, as well as both parties' rights to a fair and impartial jury trial. Pretrial publicity is of particular concern because it can taint the prospective jury pool. Hi, sweetie, you got to get off this desk. To protect the parties' fundamental rights, the court, on its own motion, issues the following. Okay, so first off, this is the factual basis. This is the factual basis to justify gagging people in the case, right? A lot of publicity. People are interested in the case. It might. Maybe it would compromise the fairness of the trial or taint the jury pool. Maybe it would. So independently, without anybody asking, the court has decided it's going to issue the following protection order. I wish they would just call it a gag order. You guys remember in Koberger when Judge was like so offended that it was called a gag order? It's a freaking gag order. Like, just lean into it. Acknowledge what it is that you're doing. You're telling people to shut up. Okay, that's what it is. I'm going to call it a gag order. I don't care what kind of euphemisms you want to use when you talk about it. Lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. Rule 3.6 prohibits a lawyer from making an extrajudicial statement that the lawyer knows or reasonably should know, will be disseminated by means of public communication, and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So once again, we have one of these orders that's just kind of restating what the rules of professional responsibility already are. And so the only effect that it really has, it doesn't necessarily impose any new obligation, but what it does is it makes it enforceable through the court's contempt power. Instead of just being referred over to the bar association, whoever handles the disciplinary stuff in that particular jurisdiction, they may or may not care about statements that you make. These are not exactly the kinds of ethical complaints that get people excited. You know, the stuff that you read about when you get the disciplinary notices in your bar journal or whatever. They're almost always about money. They're about sticking your fingers in the client's trust fund. That's the stuff that the bar gets most excited about. Sometimes they'll take an interest in things like, you know, you took the guy's case, you didn't file it, blew his statute of limitations, and then you didn't call him back for like 3 years. You'll sometimes see a case like that too. I can't remember a single time I've ever seen, somebody's going to be disciplined over violating the rule on pretrial publicity. It just doesn't happen. So in that sense, we do this order so that it can have some teeth, but they go beyond it, right? They go beyond it because we're going to talk now about who this applies to. And there is more that we're going to get to here, but just this first line: lawyers who will yet participate in the investigation or litigation of the case. Future lawyers. You may not even know. You may not even know you're going to be a lawyer in the case, but you're going to be bound by this. It's just bizarre. Like, is this supposed to be a way to kind of disqualify anybody who's like made a statement about the case from coming in and being part of the part of the case, like being one of the representatives? It's really odd. And part of the reason why it's so odd is because the whole justification for this rule, this professional conduct rule, is the idea that lawyers, when they make public statements about their cases, they have exceptional credibility and importance because they have inside information. Like, we understand they've talked to the people, they've read the case file, they know stuff that's non-public. So when they say something about it, it carries a lot of extra weight. Somebody who's not yet a part of the case doesn't have any of that. They're just any random, schmo like the rest of us who's talking about it. So it's a little bizarre. Okay. I find this very bizarre. Future lawyers, unknown future lawyers, are bound by this protection order. Let's move on. lawyers who have participated, who are now participating, or who will yet participate, more future lawyers, in the investigation or litigation of this case shall not intentionally, knowingly, or recklessly permit a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in the investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. How do you like that? How do you like that? We're not going to impose this order specifically on the witness, investigator, consultant, staff member, or other member of the team. But by the way, law enforcement, we're not going to mention law enforcement specifically. We're not going to call that out. No, so we're not going to make this order directly applicable to them. We are going to make the lawyers the keeper of those people and apparently responsible for what those people say. How is it up to the lawyer to let a witness talk? Okay? If just hypothetically, theoretically, let's say Tyler Robinson's family wanted to go out and speak. They wanted to give an interview. They wanted to clarify, this is what our role was. This is what we told the FBI. This is, what we think about the situation. Is it somehow the defense lawyer, the public defender representing their son? Is it somehow that person's job to keep them from doing that? They have no power to do that. It's not their client. And frankly, even when it's in your client, sometimes you really do. And if you don't, you maybe should do the whole dive over the desk, get the hand over the mouth. Talked about that a little bit with some of those Karen Reed interviews. What are you even there for if not to dive across the room and stick your hand in front of your mouth? You're not going to say that. We're not going to be saying that in this interview. But that's your client. Okay? These people are not your client. So it's just this very troubling expansion of responsibility of the lawyer for what other people say, and they have absolutely no control over it. Future lawyers too, by the way, we're still talking about future lawyers here. I have nothing to do with the case right now, but might in the future. But this is wild. This is wild. This protection order applies to lawyers who are not participating in the investigation or litigation of this case, but who are associated with the Utah County Attorney's Office or associated with defense counsel's firms or firms. So we are going to impute responsibility to this order to everybody that is in a professional relationship with the defense lawyers or the prosecuting attorneys. Court staff is also ordered not to make public statements that would violate the provisions of this order. This order does not prohibit lawyers from making statements prohibited by Rule 3.6. Yes, there are certain statements that are allowed to be made even under the rule. So we're not ruling those out, and that's at least some kind of limitation. Dated this 16th day of December 2025. 16th of December, guys. This thing's been out here a month. It's been out here a month, and where's the challenge? We've heard nothing. Right? No, nobody seems to have an interest in this as far as the media is concerned. So this order itself, extremely broad in terms of who it applies to, extremely questionable in terms of, does a lawyer even have the power to shut up a witness? You can tell them. I mean, is that all that this order is ultimately going to do, is just impose an obligation on the lawyers to pass on? Here's what the judge says about this order, so it'd be really good if you didn't, but the order doesn't actually tell you you can't. It just says, I'm going to be the one that takes the blame if you do. I'll be like, great, thanks. Appreciate you taking that one for the team. And like we already mentioned, this very nominal factual predicate and done on the court's own motion. Nobody asked for this. The court decided to do it themselves, and just based on, well, people are interested in this case, so this could be an issue. Guys, this is a huge problem from a First Amendment standpoint. You do not lose your First Amendment rights just because you witness a crime. This is crazy. This is crazy stuff. So, yeah, I went down the rabbit hole. I had to go down the rabbit hole with this one. Because it's just they're becoming so cavalier about it. Like, it's just no big deal. It's just no big deal to shut people up, to threaten them with the coercive power of the state, of the government, to threaten you with jail and contempt for speaking. And they don't even call out law enforcement. They don't even call out law enforcement. Absolutely kills me. Look at this. Look at this. Witness, investigator, consultant, staff member, or other member of the prosecution or defense team. The FBI is not a member of the prosecution team. Okay? It's a completely different organization, independent, not subject to law enforcement, not a member of the prosecution team, different agency. We don't even specifically call out law enforcement in this, right? And so we know what the pattern is. We know what the pattern is in these high profile cases, especially ones where there's a high profile incident like this. There's a lot of attention to the initial investigation, the arrest, and then we get a gag order, right? Because we hear all this stuff from law enforcement. We hear their perspective. And then we get a gag order and the defense has to shut up. The defense doesn't get to come out and try to even the playing field. But this is all, ostensibly to protect the right to a fair trial. Now, do we want cases tried in the public square? No, probably not. Probably not. We do want, we want the litigation to happen in the courtroom. But once somebody has been accused, once the accusation is out there, once we've got the information about the investigation, why do they think it's this person? Here's what they found. They don't even get to defend themselves. So how is that not going to automatically skew the case in favor of the prosecution? It's a big difference between, trying somebody in the public square and just pointing out, hey, here's this or that and the other that you haven't heard. You didn't hear these parts of the situation when the prosecution filed their probable cause. And so maybe just, withhold judgment and wait until we can vet this whole thing through the trial process. Part of the issue here, I think, is that, back at the time of the founding, even, 100 years ago, 50 years ago, maybe, you get charged with a crime and you have your trial a few months later. That is not today's world. Today's world is you get charged with a crime, the accusations and the evidence that justified the arrest, that is out there in the news, in the public arena, and you might not get tried for years. And so the whole time, every time there's a news story about the case, what do they have? They have that same initial information, the accusation, the evidence against you. It gets repeated over and over and over again. And that becomes the story of the case because the defense is gagged and they don't get to put their story out there. And so for years that gets reinforced until there's a trial, or, maybe there isn't. Maybe there is no trial because, like, look, I'm not going to get a fair shake here. You do the plea deal. And then you may never know what some of the evidence is. You may never know. So this is just, for me, it's a troubling, very troubling state of affairs. This is not an even playing field when it comes to information about the case. It does not create a fairer situation to shut up the defense right after the prosecution has gotten their initial accusation out and blown it up. And just from a kind of fundamental perspective, it does not help the credibility of the courts to be shutting up criticism of their processes. Okay, if the defense doesn't think they're getting a fair shake, yeah, they should have every opportunity to be able to express that, because that's an important part of our system of government, of the people, by the people, for the people. It's ours. But somehow judges and trials are supposed to be this untouchable third rail. So yeah, I see this order. I see some initial problems with it. So let's go ahead and turn to talking about why. Okay, because there is some law about this. There is definitely some law about this. But it's not nearly as straightforward as you might think. You might think, hey, First Amendment, Supreme Court's probably said something about it. Well, they kind of have, but it's never that simple. Every decision of the U.S. Supreme Court then gets picked apart by lower courts in later decisions where they decide, well, but this particular fact is different from that fact, therefore that doesn't apply, therefore we are going to do something different. And that's how the law evolves, is by distinguishing what the U.S. Supreme Court has said, because we don't want to apply it to future cases. And in this particular arena, boy, from my perspective, the reasoning behind it is completely inconsistent, often incoherent. So this is the kind of landmark case on the issue of gag orders with respect to trials. Okay, don't get to talk about evidence and things like that in the case. So check the date, right? Back in 1976. This is the last time the U.S. Supreme Court has looked at this particular issue. When can courts shut people up from talking about what is going on in the courtroom? So I'm going to skip past the syllabus here and go down. This is a Chief Justice Berger opinion. The respondent state district judge entered an order restraining the petitioners from publishing or broadcasting accounts of confessions or admission made by the accused or facts strongly implicative of the accused in a widely reported murder of 6 persons. We granted certiorari to decide whether the entry of such an order on the showing made before the state court violated the constitutional guarantee of freedom of the press. Couple very important points here. This was an order to the press. You may not publish. You may not publish this information that you've obtained. It's going to be important because that's going to be one of the key factors that courts down the road are going to say, well, this doesn't really apply, so we're going to do things a little bit differently. And the nature of the order, what you can't talk about, content from the court process, and the standard. We're going to be looking at the standard to be able to enter an order like this. That's ultimately what this case is about, the standard to gag the press from reporting about court proceedings. So on the evening of October 18th, 1975, local police found the 6 members of the Henry Kelly family murdered in their home in Sutherland, Nebraska, a town of about 850 people. Police released the description of a suspect, Irwin Charles Simmons, to the reporters who had hastened to the scene of the crime. Simmons was arrested and arraigned in Lincoln County Court the following morning, ending a tense night for this small rural community. Sound familiar? The crime immediately attracted widespread news coverage by local, regional, and national newspapers, radio, and television stations. 3 days after the crime, the county attorney and Simmons's attorney joined in asking the county court to enter a restrictive order relating to matters that may or may not be publicly reported or disclosed to the public. Because of the mass coverage by news media and the reasonable likelihood of prejudicial news, which would make difficult, if not impossible, the impaneling of an impartial jury and tend to prevent a fair trial. People are interested in the case, and so if the news media talks about it a lot, that might taint the jury. The county court heard oral argument but took no evidence. No attorney for members of the press appeared at this stage. The county court granted the prosecutor's motion for a restrictive order and entered it the next day. So again, didn't take any evidence. In this case, the prosecutor actually asked for it. In the Tyler Robinson case, the judge just did it on their own without taking any evidence. The order prohibited everyone in attendance from releasing or authorizing the release for public dissemination in any form or manner whatsoever, any testimony given or evidence adduced. The order also required members of the press to observe the Nebraska Bar Press guidelines. Simmons's preliminary hearing was held the same day, open to the public, but subject to the order. The county court bound over the defendant for trial to the state district court. The charges, as amended to reflect the autopsy findings, were that Simmons had committed the murders in the course of a sexual assault. That's going to get even more attention on it, right? It's salacious. Petitioners, several press and broadcast associations, publishers, and individual reporters, a bunch of people of the press, moved on October 23rd for leave to intervene in the district court, asking that the restrictive order imposed by the county court be vacated. The district court conducted a hearing at which the county judge testified, and newspaper articles about the Simmons case were admitted in evidence. The district judge granted petitioner's motion to intervene and on October 27 entered his own restrictive order. The judge found, because of the nature of the crimes charged in the complaint, that there is a clear and present danger that pretrial publicity could impinge upon the defendant's right to a fair trial. Nature of the crimes. It's salacious allegations, but also a higher standard now that the court is using a clear and present danger. Before it was just, there's a reasonable likelihood of prejudicial news, which would make difficult, if not possible, the impaneling of an impartial jury. The order applied only until the jury was impaneled and specifically prohibited petitioners from reporting 5 subjects. 1, the existence or contents of a confession Simmons had made to law enforcement officers, which had been introduced in open court at arraignment. 2, the fact or nature of statements Simmons had made to other persons. 3, the contents of a note he had written the night of a crime. 4, certain aspects of the medical testimony at the preliminary hearing. And 5, the identity of the victims of the alleged sexual assault and the nature of the assault. It also prohibited reporting the exact nature of the restrictive order itself. Like the county court's order, this order incorporated the Nebraska Bar Press guidelines. Finally, the order set out a plan for attendance, seating, and courthouse traffic control during the trial. So up until the jury's impaneled, the jury's sworn, we've selected them and they're seated, the press is being barred from reporting on information that was reported in court, in open court. 4 days later, petitioners asked the district court to stay its order. This is largely just procedural stuff, so we can kind of skip through it. It's not super important. And Nebraska Supreme Court says, it's, this interests that have to be balanced. And because of the publicity, the right to a fair trial is in jeopardy. So the court noted that Nebraska statutes required the district court to try Simmons within 6 months of his arrest, and that a change of venue could move the trial only to adjoining counties, which had been subject to essentially the same publicity as Lincoln County. So 6 months of the arrest, that's our speedy trial limit, back in 1976. It's a short period of time, right? And this goes to the potential effect that pretrial publicity will have on the jury. One of the cases that they're going to talk about in here, I've talked about before. It's come up in many, many different contexts. Gentile versus State Bar Association of Nevada. Actually, they don't talk about it in here because it came after this one. It talks about it in some other cases that we're going to look at here. Just a few, guys. Gentile looked at rule of professional conduct that essentially it's the same one that we have here in this protective order. Most states have one like this. It says they can prohibit lawyers from making statements about cases they're involved in when it would have a substantial likelihood of materially prejudicing the jury. And the court in Gentile basically said, yes, that's an acceptable standard, but there's a lot of things that you have to look at to evaluate whether a particular statement meets that standard. And one of the things that is an important consideration is the length of time until the trial. Because if a particular fact gets reported, in October of this year, and we don't have trial until 3 years down the road, people who are being called for jury duty may very well have forgotten it by then. So the time to trial is just a significant difference, I think, in today's world than they had back in 1976 and the earlier times when a lot of these cases were being decided. So anyway, oh my God, I got cats everywhere. Cats everywhere. Sorry, guys. Off you go. Off you go. The Nebraska Supreme Court, looked at the case, kind of tweaked it a little bit more. And so entered this modified order that just restricted 3 things: the existence and nature of any confessions or admissions made by the defendant to law enforcement, any confessions or admissions made to any third parties except members of the press. So basically, if they get to independently get details of stuff, they can report it. But if it was, up in court or made to, look at that long cat. Look how long you are. Look how long you are. Goofy. This is little Gus. I know Gus is kind of a crowd pleaser because of his little pink nose, and he is a sweetie. Cat, you got to get off that keyboard. Any other facts strongly implicative of the accused. So basically the stuff that came out in court or through, law enforcement activity, they can't report, but if they're able to independently get the information, they can. They did not rely on the guidelines. Court remanded the case for consideration of whether pretrial hearings should be closed to the press and to the public. So, just really, really trying to shield this case, this particular prosecution, from public inspection. So the U.S. Supreme Court granted certiorari to address the important issues raised by the district court order. This is the bad cat. This is the bad cat right here. Yes, Corona Morales. She's the climber. Look at you. Look at you. You're so bad. You're so bad. Gus, hang on, guys. Give me a sec here. Gus, off you go. They did not stay the trial, so subsequently he was convicted of murder and sentenced to death, and his appeal is pending in the Nebraska Supreme Court. So even gagging the press did not change the outcome of what they seem to be concerned about, right? If his confession is out there, people will assume that he's guilty. Well, it sounds like hearing the evidence at trial was enough to get them there anyway. The order at issue in this case expired by its own term. So when the jury was impaneled, so the order is moot, and they go through this argument, this discussion of whether they should consider it anyway, because, hey, if the order is no longer in effect, then our decision isn't going to do anything to the order. But they decide they're going to review it anyway, because this is a type of issue that is capable of repetition and yet will be likely to evade review. Just because of the timeline of appeal and trial and stuff like that, it's likely that an order like this is going to be mooted every time it comes up. So therefore, they go ahead and decide we are going to look at the case, even though the order is no longer effective. So we can't strike down the order. It's already done. Now we get into the meat of the case. Okay, the reasoning and the standards that they set. So the problems presented by this case are almost as old as the Republic. Neither in the Constitution nor in contemporaneous writings do we find that the conflict between these two important rights was anticipated, yet it is inconceivable that the authors of the Constitution were unaware of the potential conflicts between the right to an unbiased jury and the guarantee of freedom of the press. You think John Adams, who defended the British in Massachusetts, where something like 12 of the only 18 printing presses in the colonies at the time existed, you don't think he was concerned? He'd given any thought to that? Yes, of course they had. But no, they didn't spell it out. The unusually able lawyers who helped write the Constitution and later drafted the Bill of Rights were familiar with the historic episode in which John Adams defended British soldiers charged with homicide for firing into a crowd of Boston demonstrators. They were intimately familiar with the clash of the adversary system and the part that passions of the populace sometimes play in influencing potential jurors. They did not address themselves directly to the situation presented by this case. Their chief concern was the need for freedom of expression in the political arena and the dialogue in ideas. But they recognized that there were risks to private rights from an unfettered press. Jefferson, for example, writing from Paris in 1786 concerning press attacks on John Jay, stated, "In truth, it is afflicting that a man who has passed his life in serving the public should yet be liable to have his peace of mind so much disturbed by any individual who shall think proper to arraign him in a newspaper. It is, however, an evil for which there is no remedy. Our liberty depends on the freedom of the press, and that cannot be limited without being lost." So, that kind of sounds like they did think about it, and they did, in fact, reconcile that conflict in favor of putting in a First Amendment to the U.S. Constitution that the freedom of the press shall not be abridged. The trial of Aaron Burr in 1807 presented Mr. Chief Justice Marshall, presiding as a trial judge, with acute problems in selecting an unbiased jury. Few people in the area of Virginia from which jurors were drawn had not formed some opinions concerning Mr. Burr or the case from newspaper accounts and heightened discussion, both private and public. The Chief Justice conducted a searching voir dire of the two panels eventually called and rendered a substantial opinion on the purposes of voir dire and the standards to be applied. Burr was acquitted, so there was no occasion for appellate review to examine the problem of prejudicial pretrial publicity. So, pardon me if I'm finding this a little bit incoherent, okay? There's grave concern raised by the pretrial publicity about Aaron Burr, in which he apparently got a perfectly fair trial. Okay, they let him off. He was charged with treason against the United States. If you don't think that is salacious and damaging and stuff, I mean, yeah, I think it would be, but he got a free trial. So there was no occasion for appellate review. Yeah, because maybe there wasn't a problem. Maybe pretrial publicity wasn't a problem. Mr. Chief Justice Marshall's careful voir dire inquiry into the matter of possible bias makes clear that the problem is not a new one. No, from time immemorial in selecting jurors, that's part of what you get into is what do you know about the case and what sort of opinions, what sorts of prior opinions have you already formed about it? Pretrial publicity, okay, it didn't affect the fairness of the trial. Why? Possibly because they went through and did this questioning and they were able to eliminate people whose opinions are too fixed. That's kind of what the law presumes and what case law has presumed up into, extremely recent days. The Dzhokhar Zayarnev case, the Boston Marathon bomber, his case went all the way up on the issue of, God, I didn't look at this one before, so I'm kind of going by ear, and I may have the exact specifics off. But if I remember correctly, it was the fact that his attorneys didn't get to do their own voir dire. It was a judge-led voir dire of the jury panel, which I think is common in federal court. That might be the norm there. I don't know. I don't do federal trials, and so. Boston Marathon case, extensive publicity, whole Reddit manhunt, that didn't exactly go all that well at the end of the day. Massive amount of information about it, a lot of prejudgment about it, and so forth. The defendant had argued, by not being able to do our own questioning into the scope of what people had learned about the case, potential jurors, what they knew, the type of effect it might have had on them. We can't guarantee he had an unbiased jury. And the Supreme Court said, well, basically, if the jurors said, yeah, we've heard about the case, but we can be fair and unbiased, that's what we go by. Okay, that's what we go by. They say they could be fair. If they said they could be fair, that's what you're entitled to in terms of an impartial jury. It's just they said so. Okay, you don't necessarily get to vet that to make that determination yourself. So that's this tension, right? In this pretrial publicity kind of context is, it can really, really affect people, even though apparently it didn't. And even though we have these processes that at least in theory are there to weed people out, and even if we just kind of pay that lip service because we give full credit to them saying they can be unbiased without actually testing whether they can be unbiased or not. It's just, I hate to say it, but it's kind of one of these situations where, once again, the law just sort of follows the outcome that they want to reach in the case. They didn't want to give Dzhokhar Zayarnev a new trial. They didn't want to have to do that. So they didn't want to have to change the rules about voir dire in federal court in capital cases. So no, it's good enough that they said so. And you just unfortunately see a lot of that in the law where they say the saying is hard cases make bad law. They don't want to reach the outcome that a principled application of a principle would require them to reach. So they find a workaround, and it just creates a lot of conflict, incoherence, and messiness. The point of all this being, hey, if you can sort people out by voir dire to the extent that the pretrial publicity even is a problem, if you can sort them out by voir dire, why would you need a gag order? Just keep that in mind. The speed of communication and the pervasiveness of the modern news media have exacerbated these problems, however, as numerous appeals demonstrate. Isn't that funny? Coming from 1976, the speed of communication and the pervasiveness of the modern news media. If they could only have imagined where we are today. The trial of Bruno Hauptmann in a small New Jersey community for the abduction and murder of the Charles Lindbergh's infant child probably was the most widely covered trial up to that time, and the nature of the coverage produced widespread public reaction. Criticism was directed at the carnival atmosphere that pervaded the community and the courtroom itself. This is a very common, look at this long cat. Look how long he is. Look at that long cat. This is a common criticism that comes up anytime they want to criticize the press or take issue with the press's interaction in a court case. A carnival atmosphere. That's the way that they describe it. It's come up in multiple different cases. It came up in Sheppard versus Maxwell is probably the most famous one, where they reversed a defendant's conviction because the press created this carnival atmosphere. They were like taking over the courthouse and yelling out questions and things like that. Very disruptive. Just kind of making a mess of things. But even then in a later case, Estes versus Texas. Okay, Estes versus Texas, kind of a wild case, U.S. Supreme Court case where they said televising a trial is a violation of due process. Now, they came back in the early 1980s and said, well, we didn't mean like inherently in every single case televising it is a violation of due process. But in Estes versus Texas, they kind of did say that. They really did. Because they talked about the nature of televising it. There's cameras everywhere. People know the cameras are on them. It's going to affect the way that the courtroom participants behave. They're going to play to the camera. It's disruptive to the process. Just kind of difficult to get out of that reasoning to, saying, but we only meant that in this particular case where there was a carnival atmosphere. But again, the evidence of that was just basically, well, there were multiple cameras in the courtroom and people walked around and stuff like that. So anyway, just always notice that language, the carnival atmosphere, when we're going to criticize how the press behaves in the court. That's what they come up with. Responsible leaders of press and the legal profession, including other judges, pointed out that much of this sorry performance could have been controlled by a vigilant trial judge and by other public officers subject to the control of the court. The excesses of press and radio and lack of responsibility of those in authority in the Hauptmann case and others of that era led to efforts to develop voluntary guidelines for courts, lawyers, press, and broadcasters. The effort was renewed in 1965 when the American Bar Association embarked on a project to develop standards for all aspects of criminal justice, including guidelines to accommodate the right to a fair trial and the rights of a free press. The resulting standards, approved by the association in 1968, received support from most of the legal profession. Other groups have undertaken similar studies. In the wake of these efforts, the cooperation between bar associations and members of the press led to the adoption of voluntary guidelines like Nebraska's. In practice, of course, even the most ideal guidelines are subjected to powerful strains when a case such as Simmons's arises, with reporters from many parts of the country on the scene. Reporters from distant places are unlikely to consider themselves bound by local standards. They report to editors outside the area covered by the guidelines, and their editors are likely to be guided only by their own standards. Boy, and if they had only anticipated YouTubers and podcasters. Oh, those standardless grifters. To contemplate how a state court can control acts of a newspaper or broadcaster outside its jurisdiction, even though the newspapers and broadcasts reach the very community from which jurors are to be selected, suggests something of the practical difficulties of managing such guidelines. It does, doesn't it? And it also perhaps harkens to difficulties in enforcing restrictions on who can speak. But we'll get to that too. The problems presented in this case have a substantial history outside the reported decisions of the courts in the efforts of many responsible people to accommodate the competing interests. We cannot resolve all of them, for it is not the function of this court to write a code. We look instead to this particular case and the legal context in which it arises. So that was just kind of a fun, historic background with some famous historic cases and role that those played in developing the principles that are going to emerge here in the Nebraska press case. The Sixth Amendment, in terms, guarantees trial by an impartial jury in federal criminal prosecutions. Because trial by jury in criminal cases is fundamental to the American scheme of justice, the Due Process Clause of the 14th Amendment guarantees the same right in state criminal prosecutions. In essence, the right to a jury trial guarantees to the criminally accused a fair trial by a panel of impartial, indifferent jurors. A fair trial in a fair tribunal is a basic requirement of due process. In the ultimate analysis, only the jury can strip a man of his liberty or his life. In the language of Lord Coke, a juror must be as indifferent as he stands unsworn. His verdict must be based upon the evidence developed at the trial. In the overwhelming majority of criminal trials, pretrial publicity presents few unmanageable threats to this important right. But when the case is a sensational one, tensions develop between the right of the accused to trial by an impartial jury and the rights guaranteed others by the First Amendment. The relevant decisions of this court, even if not dispositive, are instructive by way of background. In Irvin versus Dowd, for example, the defendant was convicted of murder following intensive and hostile news coverage. The trial judge had granted a defense motion for a change of venue, but only to an adjacent county, which had been exposed to essentially the same news coverage. At trial, 430 persons were called for jury service. 268 were excused because they had fixed opinions as to guilt. 8 of the 12 who served as jurors thought the defendant guilty, but said they could nevertheless render an impartial verdict. On review, the court vacated the conviction and death sentence and remanded to allow a new trial, for, with his life at stake, it is not requiring too much that petitioner be tried in an atmosphere undisturbed by so huge a wave of public passion. Well, that was then. Dzhokhar Tsarnaev is now. So today, they're not going to follow Irvin versus Dowd. They're going to say the jurors said they could render an impartial verdict, and that's all that we are going to care about. Similarly, in Rideau versus Louisiana, the court reversed the conviction of a defendant whose staged, highly emotional confession had been filmed with the cooperation of local police and later broadcast on television for 3 days while he was awaiting trial, saying any subsequent court proceedings in a community so pervasively exposed to such a spectacle could be but a hollow formality. Did you guys see, just within the last couple weeks, some guy, I can't remember the details, the guy's name or where it happened or anything like that, but he did a news interview. It was a situation where his parents had like gone missing years before, and ultimately the police found him in the backyard, dug him up, found him in a grave in the backyard. And so the surviving son then goes and gives an interview on TV, and this newscaster, to his credit, is quite a fairly hard interrogator, and he gets the guy to confess. He kills the parents, how he killed the parents, how he did it, what he did, what his reasoning was behind it, all in this interview that was broadcast on TV. Do we think they're going to not try him now because they did that? No, of course not. Of course not. To the extent that this case even has any continuing power at this point in time, it's still good law, but people find all the different ways to distinguish it. Like, well, he's not going to have a trial for a while, so, we'll ask the jury if they can be fair, and that will be that. So, these principles, they just aren't really that binding. And in Estes versus Texas, this is the one I mentioned, The court held that the defendant had not been afforded due process, where the volume of trial publicity, the judge's failure to control the proceedings, and the telecast, it was really about the televising, the telecast of a hearing and of the trial itself inherently prevented a sober search for the truth. That's what they said. They really did. They said it inherently violates due process to televise a court hearing. They came back in like 1980, early 1980 something in Chandler versus Florida and say, no, we never said that. They gaslight us, right? If everything else being equal, if we can't distinguish the case, we'll just gaslight everybody about what we actually said. We never said it inherently. And inherently, here it is, right here, quote marks on it, inherently prevented a sober search for the truth. In Sheppard v. Maxwell, this is the famous one, the court focused sharply on the impact of pretrial publicity and a trial court's duty to protect the defendant's constitutional right to a fair trial. With only Mr. Justice Black dissenting, and he without opinion, the court ordered a new trial for the petitioner, even though the first trial had occurred 12 years before. Beyond doubt, the press had shown no responsible concern for the constitutional guarantee of a fair trial. The community from which the jury was drawn had been inundated by publicity hostile to the defendant, but the trial judge did not fulfill his duty to protect the defendant from the inherently prejudicial publicity which saturated the community and to control disruptive influences in the courtroom. The court noted that unfair and prejudicial news comment on pending trials has become increasingly prevalent and issued a strong warning. Due process requires that the accused receive a trial by an impartial jury free from outside influences. Given the pervasiveness of modern communications and the difficulty of effacing prejudicial publicity from the minds of the jurors, the trial courts must take strong measures to ensure that the balance is never weighed against the accused. Really? It sounds nice, because that is not what we do in this day and age. Of course, there is nothing that prescribes the press from reporting events that transpire in the courtroom. But where there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until the threat abates or transfer it to another county not so permeated with publicity. Hi, sweetie. In addition, sequestration of the jury was something the judge should have raised sua sponte with counsel. If publicity during the proceedings threatens the fairness of the trial, a new trial should be ordered. But we must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. The court must take such steps by rule and regulation that will protect their processes from prejudicial outside interferences. Neither prosecutors, counsel for defense, the accused, witnesses, court staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. Collaboration between counsel and the press as to information affecting the fairness of a criminal trial is not only subject to regulation, but is highly censurable and worthy of disciplinary measures. It was very much the old school perspective on lawyers talking to the press. You just didn't. It was unseemly to do that. And then, at least from my perspective, Adam Waldman came along, blew that out of the water, defended his client in the court of public opinion, which had been a very one-sided battle against him up to that point. Released the audio recordings of Amber Heard in the act of abusing him, and pretty much overnight changed the tide of that particular situation. And then, of course, since then, that was, from my perspective, like one of the first really high-profile cases I can remember of the attorney presenting the case in public, responding in public to the accusations that had been made in public against his client. He suffered a consequence for that, right? He got removed from the case. He wasn't allowed to be Johnny's attorney. But then since then, it just seems like it has grown. I mean, look at the Blake Lively, Justin Baldoni thing. Baldoni's lawyer set up like a whole website to put out their version, their defense. Um, just kind of becoming more and more common now for lawyers to be more aggressive when it comes to press management. Alex Spiro has been doing this as well. So it's just a very different environment that we live in than back when this was written in 1976. Because the trial court had failed to use even minimal efforts to insulate the trial and the jurors from the deluge of publicity, the court vacated the judgment of conviction and a new trial followed in which the accused was acquitted. 12 years. Hey, 12 years was enough, right? Apparently. Cases such as these are relatively rare, and we have held in other cases that trials have been fair in spite of widespread publicity. In Strobel versus California, for example, the court affirmed a conviction and death sentence challenged on the ground that pre-trial news accounts, including the prosecutor's release of the defendant's recorded confession, were allegedly so inflammatory as to amount to a denial of due process. Look at this unique fact in here. The prosecutor did something. Well, we would hate to make case law that chastises a prosecutor, wouldn't we? So we'll find a reason to make it okay in that case. The court disapproved of the prosecutor's conduct, but noted that the publicity had receded some 6 weeks before trial. The defendant had not moved for a change of venue, and the confession had been found voluntary and admitted in evidence at trial. So, guys, this is the demonstration of how they do it. Okay, we want to reach an outcome in this particular case. We'll find a reason. We don't want to reach that outcome in another case. We'll find another reason. We'll shake our finger. We'll wag our finger very vigorously at that prosecutor. Bad one, but we won't impose an actual consequence. No actual consequence, because that might be serious. 6 weeks was all it took for the publicity to abate. 6 weeks. And nothing in today's era. The court also noted the thorough examination of jurors on voir dire and the careful review of the facts by the state courts, and held that petitioner had failed to demonstrate a denial of due process. This is just a fancy way of saying, look, guys, we're pretty sure he's guilty anyway, so we're not gonna do anything about it. We're gonna say it's fine. But again, we have this theme that voir dire is the remedy for pretrial publicity. Talking to the jurors about what they know and sorting out the ones who know too much or have too firm opinions. That's the way you mitigate the fact that the public, as they have a right to do, sometimes takes interest in high-profile cases. Taken together, these cases demonstrate that pre-trial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. The capacity of the jury eventually impaneled to decide the case fairly is influenced by the tone and extent of the publicity, which is in part and often in large part shaped by what attorneys, police, and other officials do to precipitate news coverage. The trial judge has a major responsibility. What the judge says about a case in or out of the courtroom is likely to appear in newspapers and broadcasts. More important, the measures a judge takes or fails to take to mitigate the effects of pretrial publicity. There's some typo here. The measures described in Sheppard may well determine whether the defendant receives a trial consistent with the requirements of due process. That this responsibility has not always been properly discharged is apparent from the decisions just reviewed. The costs of failure to afford a fair trial are high. In the most extreme cases like Sheppard and Estes, the risk of injustice was avoided when the convictions were reversed. But a reversal means that justice has been delayed for both the defendant and the state. In some cases, because of lapse of time, retrial is impossible or further prosecution is gravely handicapped. Moreover, in borderline cases in which the conviction is not reversed, there is some possibility of an injustice unredressed. The strong measures outlined in Sheppard v. Maxwell are means by which a trial judge can try to avoid exacting these costs from society or from the accused. The state trial judge in the case before us acted responsibly out of a legitimate concern. He meant well, guys. He meant well. What do we say about good intentions? Where is the road paved? Where is the road to hell? Road to hell paved with good intentions? What we must decide is not simply whether the Nebraska courts erred in seeing the possibility of real danger to the defendant's rights, but whether in the circumstances of this case, the means employed were foreclosed by another provision of the Constitution. So a very long section going over the right to a fair trial, impartial jury, and the significance of all of that. The First Amendment provides that Congress shall make no law abridging the freedom of the press, and it is no longer open to doubt that the liberty of the press and of speech is within the liberty safeguarded by the Due Process Clause of the 14th Amendment from invasion by state action. The court has interpreted these guarantees to afford special protection against orders that prohibit the publication or broadcast of particular information, or commentary orders that impose a previous or prior restraint on speech. None of our decided cases on prior restraint involved restrictive orders entered to protect a defendant's right to a fair and impartial jury. But the opinions on prior restraint have a common thread relevant to this case. Prior restraint means gag order, means we're saying you can't say something before you say it, rather than letting you say it and then either punishing you or doing some kind of mitigation after the fact. A prior restraint before you speak. In Neer versus Minnesota, the court held invalid a Minnesota statute providing for the abatement as a public nuisance of any malicious, scandalous, and defamatory newspaper, magazine, or other periodical. Neer had published an occasional weekly newspaper described by the county attorney's complaint as largely devoted to malicious, scandalous, and defamatory articles concerning political and other public figures. This kind of sounds like run-of-the-mill leafletting at the time of the founders, the pamphleteering. Sounds like pretty routine. Publication was enjoined pursuant to the statute. Excerpts from Neer's paper, set out in the dissenting opinion of Mr. Justice Butler, show beyond question that one of its principal characteristics was blatant anti-Semitism. Mr. Chief Justice Hughes, writing for the court, noted that freedom of the press is not an absolute right, and the state may punish its abuses. He observed that the statute was not aimed at the redress of individual or private wrongs. He then focused on the statute. The operation and effect of the statute in substance is that public authorities may bring the owner or publisher of a newspaper or periodical before a judge upon a charge of conducting a business of publishing scandalous and defamatory matter. And unless the owner or publisher is able to satisfy the judge that the matter is true and published with good motives, his newspaper or periodical is suppressed. This is of the essence of censorship. Think so? The court relied on Patterson v. Colorado. The main purpose of the First Amendment is to prevent all such previous restraints upon publications as had been practiced by other governments. The principles enunciated in Neer were so universally accepted that the precise issue did not come before us again until Organization for a Better Austin versus Keefe. There, the state courts had enjoined the petitioners from picketing or passing out literature of any kind in a specified area. Noting the similarity to Neer versus Minnesota, a unanimous court held, here as in that case, the injunction operates not to redress alleged private wrongs, but to suppress, on the basis of previous publications, distribution of literature of any kind in a city of 18,000. Any prior restraint on expression comes to this court with a heavy presumption against its constitutional validity. It's almost always not okay to say you're not allowed to say something, you're not allowed to publish something. Respondent thus carries a heavy burden of showing the justification for the imposition of such a restraint. He has not met that burden. Designating the conduct as an invasion of privacy, the apparent basis for the injunction here, is not sufficient to support an injunction against peaceful distribution of informational literature of the nature revealed by this record. Invasion of privacy, they didn't want people coming up to you and handing you something. Apparently. This must be before Vegas, right? It's on like every corner, people handing you all kinds of talk about salacious things. More recently, in New York Times Company versus US, the government sought to enjoin the publication of excerpts from a massive classified study of this nation's involvement in the Vietnam conflict, going back to the end of the Second World War, the Pentagon Papers case. The dispositive opinion of the court simply concluded that the government had not met its heavy burden of showing justification for the prior restraint. Each of the 6 concurring justices and the 3 dissenting justices expressed his views separately, but every member of the court, tacitly or explicitly, accepted the near and keef condemnation of prior restraint as presumptively unconstitutional. I hope you guys aren't too, if you are hearing the bag being crumpled, yes, that's the only thing that is keeping the cats entertained right now. I can hear it. It's like extremely loud to me, so I don't know if it's getting picked up on the mic. The court's conclusion in New York Times suggests that the burden on the government is not reduced by the temporary nature of a restraint. In that case, the government asked for a temporary restraint solely to permit it to study and assess the impact on national security of the lengthy documents at issue. The thread running through all these cases is that prior restraints on speech and publication are the most serious and the least tolerable infringement on First Amendment rights. Gag orders are the worst violation of the First Amendment. They're the worst. They're the worst. That's the thread running through the case law. A criminal penalty or a judgment in a defamation case is subject to the whole panoply of protections afforded by deferring the impact of the judgment until all avenues of appellate review have been exhausted. Only after judgment has become final, correct, or otherwise does the law's sanction become fully operative. So you don't get penalized for what you say until you have had your full due process and your opportunity to defend why you were justified in saying it. A prior restraint doesn't give you that. It just says you can't talk. And then if you do, you are in contempt of court. And the only question in contempt of court is, did you talk or not? Did the order say you weren't supposed to talk? And did you talk anyway? A prior restraint, by contrast and by definition, has an immediate and irreversible sanction. If it can be said that a threat of criminal or civil sanctions after publication chills speech, prior restraint freezes it, at least for the time. Yeah, when you look at this order in the Tyler Robinson case and you think, hey, I might be a future lawyer in this case, I better not say anything about it. That's chilling. That's freezing. That's shutting you up because you question whether you're subject to it. You question what's the scope of what I'm allowed to say or not allowed to say in light of this. It shuts people up. And shutting people up is the antithesis of the First Amendment. The damage can be particularly great when the prior restraint falls upon the communication of news and commentary on current events. Truthful reports of public judicial proceedings have been afforded special protection against subsequent punishment. There's a litigation privilege. For the same reasons, the protection against prior restraint should have particular force as applied to reporting of criminal proceedings, whether the crime in question is a single isolated act or a pattern of criminal conduct. A responsible press has always been regarded as the handmaiden of effective judicial administration, especially in the criminal field. That's the qualifier, though, isn't it? Responsible press. Responsible press. Its function in this regard is documented by an impressive record of service over several centuries. The press does not simply publish information about trials, but guards against the miscarriage of justice by subjecting the police, prosecutors, and judicial processes to extensive public scrutiny and criticism. Would that that remained the case today. The extraordinary protections afforded by the First Amendment carry with them something in the nature of a fiduciary duty to exercise the protected rights responsibly, a duty widely acknowledged but not always observed by editors and publishers. It is not asking too much to suggest that those who exercise First Amendment rights in newspapers or broadcasting enterprises direct some effort to protect the rights of an accused to a fair trial by unbiased jurors. Is it or is it not? See, that's the question. Constitutionally, are they required to? Probably not. Probably not. Press doesn't have an obligation to preserve the fair trial. Hence, the press that we have today. Of course, the order at issue, like the order requested in New York Times, does not prohibit but only postpones publication. Some news can be delayed, and most commentary can even more readily be delayed without serious injury. And there often is a self-imposed delay when responsible editors call for verification of information. But such delays are normally slight and they are self-imposed. Delays imposed by governmental authority are a different matter. We have learned and continue to learn from what we view as the unhappy experiences of other nations where government has been allowed to meddle in the internal editorial affairs of newspapers. Regardless of how beneficent sounding the purposes of controlling the press might be, we remain intensely skeptical about those measures that would allow government to insinuate itself into the editorial rooms of this nation's press. Well, they're the government. They're here to help. What could the possible downside be? Oh, geez, I don't know. Self-interest, massive self-interest, capture, narrative-driven. Maybe just, you know, the Orwellian distortion of fact and truth. Maybe just those kind of things. As a practical matter, moreover, the element of time is not unimportant if press coverage is to fulfill its traditional function of bringing news to the public promptly. The authors of the Bill of Rights did not undertake to assign priorities as between the First Amendment and Sixth Amendment rights, ranking one as superior to the other. In this case, the petitioners would have us declare the right of an accused subordinate to their right to publish in all circumstances. But if the authors of these guarantees, fully aware of the potential conflicts between them, were unwilling or unable to resolve the issue by assigning to one priority over the other, it is not for us to rewrite the Constitution by undertaking what they declined to do. It is unnecessary, after nearly 2 centuries, to establish a priority applicable in all circumstances. Yet it is nonetheless clear that the barriers to prior restraint remain high unless we are to abandon what the court has said for nearly a quarter of our national existence and implied throughout all of it. The history of even wartime suspension of categorical guarantees, such as habeas corpus or the right to trial by civilian courts, cautions against suspending explicit guarantees. The Nebraska courts in this case enjoined the publication of certain kinds of information about the Simmons case. There are, as we suggested earlier, marked differences in setting and purpose between the order entered here and the orders entered in Near, Keefe, and New York Times. But as to the underlying issue, the right of the press to be free from prior restraints, now we capitalize it, to be free from prior restraints on publication, those cases form the backdrop against which we must decide this case. We turn now to the record in this case to determine whether, as Learned Hand put it, the best name for a judge ever in history, Judge Learned Hand. Oh, he was born for it. It's better than judge. Okay. It's better than judge. Learned hand. Learned hand. I just picture him on the bench with his hand, learned hand. The gravity of the evil, discounted by its improbability, justifies such invasion of free speech as is necessary to avoid the danger. To do so, we must examine the evidence before the trial judge when the order was entered to determine A, the nature and extent of pretrial news coverage, B, whether other measures would be likely to mitigate the effects of unrestrained pretrial publicity, and C, how effectively a restraining order would operate to prevent the threatened danger. These are the findings, okay? They're telling us right here, the evidence has to establish these things as part of justifying a gag order in the place. Nature and extent of the coverage, other possible mitigation, how well it would work, why it might not work, how effectively a restraining order would work in the first place. Is this even going to shut people up? Okay. This is so important because this is what gets us back to the Kohberger case. Remember, we had breaches of the order. And what happened? Absolutely nothing. Absolutely nothing happened when the gag order was violated. And part of the reason why, number one, little bit of a different era today than back in 1976. Today, just about every single state, maybe every state now, I'm not sure, Idaho's just went into effect earlier this year, has a reporter's shield law. So you can't go to the news agency to find out who leaked to you, who gave you this information. So your ability to effectively investigate violations of a gag order, very questionable. Very, very questionable. Another problem with it, jurisdiction. Who does this court even have jurisdiction over to be able to enforce this order? And this came up with the FBI. It'll come up with the FBI potentially in the Tyler Robinson case too, because this is a state prosecution. And states do not have authority over federal investigators. This is a premise of the supremacy clause of the U.S. Constitution. The federal government is the supreme law of the land. Federal agents are not subject to process from state courts unless they want to be. This is why we have the TUI process, the TUI regulations. You guys who followed Karen Reed will remember that. It did come up in Kohberger as well. If you want to get information in a state prosecution from a federal investigative body, you'll get it on their terms if they feel like it. And they have all the processes that you have to go through to try to get it from them. And that's based on this case, this TUI case, that said, yeah, supremacy clause. They're not subject to a state court subpoena. It can't be enforced against them. So how are you going to haul in an FBI agent who decides to leak all kinds of stuff about the Tyler Robinson investigation to some news media? How are you going to get him into court? You don't even have the power to do that. So this last finding here, how effectively a restraining order would operate to prevent the threatened danger, to me, this pretty much cuts against gag orders in most cases. Certainly state cases where there are federal investigators involved. Because you have no means of enforcing it against them. Federal courts, different set of situations. Okay, federal courts, yeah, they would have jurisdiction to call in some FBI officer. Federal courts, federal statutes, there's no federal reporter's shield law. But it gets a little complicated whether a state reporter shield law is going to apply in federal court. So it's like, kind of iffy if it's going to be enforceable or not. But in state court, particularly with federal investigators, I don't see how the standard is ever met. You're never going to be able to enforce this order because you have no means of compelling the reporter to disclose a source. You can't. I mean, there's going to be some variation in state law as far as how stringent the protection is, but many states, Utah has a very stringent reporter's shield law. We could look at it, but I'm not going to pull it up right now. But if you're interested, it's URE 509, Utah Rules of Evidence 509. Specifically lays out their reporter shield law. Covers information, covers sources. They can quash a subpoena that would seek information that would disclose. So like, we want to look for your phone records, your emails, something like that, see who you communicated with. No, they can quash it. So you have no investigative tools. I don't know how on earth you're going to enforce it. The precise terms of the restraining order are also important. We must then consider whether the record supports the entry of a prior restraint on publication, one of the most extraordinary remedies known to our jurisprudence. And I just got to highlight that. This is supposed to be one of the most extraordinary remedies known to our jurisprudence, and yet it is becoming a routine thing that judges sign on their own without taking any evidence, without making any specific findings beyond, well, there's people are really interested in this case and there's a lot of publicity about it. And that might be a problem. That's not extraordinary. It has become routine, and that is a problem. In assessing the probable extent of publicity, the trial judge had before him newspapers demonstrating that the crime had already drawn intensive news coverage and the testimony of the county judge who had entered the initial restraining order based on the local and national attention the case had attracted. The district judge was required to assess the probable publicity that would be given these shocking crimes prior to the time a jury was selected and sequestered. He then had to examine the probable nature of the publicity and determine how it would affect prospective jurors. We had no record in this case. No record. Okay. Whatever the judge is looking at, we'll grant, yeah, there was a lot of publicity about this case, a lot of attention, a lot of news coverage, a lot of social media coverage, all of that. But we don't know what the judge is looking at. And as far as like the tone and tenor of the coverage, that in particular, no idea what he was looking at. Is there anything that is particularly damaging to the defendant? Is there anything that goes substantially beyond what's already out there in the public sphere? Now, there's lots and lots of stuff on social media, right? There usually is. But as far as like legitimate press, again, the only thing that really jumps to my mind is New York Post. New York Post got a picture of what they say is the firearm, like the firearm, not just a Mauser 98-30-06, but the actual one involved. And I believe they do attribute that to the FBI. Is that like grossly prejudicial to the defendant, or is it just kind of factual? Like these are facts that are going to come out that we're going to know. We had no record of any of that in this particular case. We have no evaluation of what time frame in a death penalty case we're going to be looking at before there is an actual jury selected in the case. We've had no consideration of just the fact that almost always after the initial arrest and arraignment, there's a massive fall off. There's a massive fall off in the interest in the case. And we're seeing that here. We're seeing that here. The press, I've mentioned there's something like 70 filings on the docket. And the press, as far as I can tell, the mainstream press stopped reporting at the arraignment. Maybe they mentioned his attorney. His attorney got appointed, his first public defender, Catherine Nestor. Remember her name came up. It's had 2 others since then. Have their names come out? Actually, 3 others. 3 others since then. I don't recall seeing any like news coverage about them. The process itself, not a lot. Not a lot. And that's pretty normal. That's pretty normal. We live in a soundbite driven era. We live in a short segment driven era. Depth no longer characterizes mainstream news coverage. They just want the quick and superficial take on things. And if it bleeds, it leads. And the reality is that the majority of ongoing pretrial processes are really kind of boring. They're just kind of boring. And so we had the initial flurry during the investigation, and once his name was out, in interviews, trying to find like neighbors and people who knew them back in the day, like all of that is pretty routine. It happens in most of these high profile cases. Certainly happened in Koberger too. But it falls off, and it falls off pretty fast. So I don't know what, did he even give any consideration to that? Nothing in his order, nothing in the gag order suggests he gave any consideration to what's the likely publicity going to be and how long is this going to be going on? How pervasive is it going to be? How intensive? And how prejudicial is it? Is this going to be guilt presumptive, or is it going to be objective and fair? It seems like that kind of makes a difference. Our review of the pretrial record persuades us that the trial judge was justified in concluding that there would be intensive and pervasive pretrial publicity concerning this case. He could also reasonably conclude, based on common man experience, that publicity might impair the defendant's right to a fair trial. He did not purport to say more, for he only found a clear and present danger that pretrial publicity could impinge upon the defendant's right to a fair trial. His conclusion as to the impact of such publicity on prospective jurors was of necessity speculative, dealing as he was with factors unknown and unknowable. We find little in the record that goes to another aspect of our task, determining whether measures short of an order restraining all publication would have ensured the defendant a fair trial. Although the entry of the order might be read as a judicial determination that other measures would not suffice, the trial court made no express findings to that effect. The Nebraska Supreme Court referred to the issue only by implication. Same thing here. Where is the evaluation of it will not be enough to conduct voir dire and just take their word for it when they say, yeah, I can be fair and impartial? Where is the finding that they can't, for example, temporarily seal particularly, controversial, prejudicial, inflammatory types of things? They can't just counsel the lawyers, please exercise discretion. The fact that so much of this is going to come out in court anyway, okay, there's going to be, as far as we know, a preliminary hearing. He said he doesn't intend to waive his right to a preliminary hearing. There's going to be evidence presented at the preliminary hearing, and the public is going to have a right to be there. And in Utah, the cameras are going to have a right to be there. It's going to be televised. So we're all going to see it. That's kind of got to be the backdrop against which statements to the press need to be measured. Okay, are they going to have a significant impact relative to what the public is going to be able to see with their own eyes and ears. Most of the alternatives to prior restraint of publication in these circumstances were discussed with obvious approval in Sheppard v. Maxwell. A change of trial venue to a place less exposed to the intense publicity that seemed imminent in Lincoln County. That I don't know that we're really going to have, that kind of an issue in this case. Just like in Coburg, it was everywhere. It was everywhere. So I don't know that you're going to find a county that is going to be better off. That said, is it reasonable to assume, for the same reasons that came out in the Coburg motion to change venue, that Utah County might be particularly bad from that perspective? Yeah, maybe. And part of the issue was, there's fear engendered in the hometown. You want to make sure you got the right guy. Maybe that's less in this case, where it seems to be politically motivated, and in Coburg it would just look like random, no particular motivation, just random violence. But he didn't consider change of venue at all. Postponement of the trial to allow public attention to subside. We didn't even get into how long is it going to take before this case even gets to trial. Okay. Minimum 2 years, bare minimum 2 years, 3 years. We're probably getting in the ballpark. 4 to 5, not unexpected, not unheard of. Just depends on the volume of litigation and discovery. We're once again talking about terabytes and terabytes of discovery. And that's to be expected, because what happened? The FBI and whoever else went out and did a massive canvas, a video canvas. And they got surveillance footage from the university, from all of the neighbors, from the path. Maybe once they identified who he was, he's down in St. George. Maybe they went down to St. George and get stuff down there too. I mean, a massive amount of volume of information to go through. So it's going to be a long time. Are that many people going to remember? Are going to remember what? What's not already in the public record that could be so, so prejudicial. Searching questioning of prospective jurors, as Mr. Chief Justice Marshall used in the Burr case to screen out those with fixed opinions as to guilt or innocence, we can presume there will be a voir dire in a qualification process. This is going to need to be a death qualified jury. So it's going to be it's going to be like voir dire plus. The use of emphatic and clear instructions on the sworn duty of each juror to decide the issues only on the evidence presented in open court. That's the legal fiction. We tell the jurors, leave everything you know about the case at the courthouse door and decide only based on what you hear in this trial process. And they say, yes, I will do that. And psychologically, you can't do that. That's not possible. You can't actually compartmentalize your brain like that. It has affected your perspectives. It has affected your biases about the case, potentially at a subconscious level that you're not even aware of. And that will affect, what do you pay more attention to? What do you give more credibility to? But, that's the reality. But the law isn't really in alignment with the reality on that issue, because the law says we presume the jurors will follow their instructions. So we give them an instruction. You'll only decide it based on the evidence, and we'll emphasize that. Will that help? It might, maybe. But none of that got considered by this judge. Sequestration of jurors is, of course, always available. Yeah, but that's after the fact. And that's, I don't think, the primary concern here, the risk that jurors would go and investigate stuff before trial. During trial, it's that they would be tainted before trial. Although that measure insulates jurors only after they are sworn, it also enhances the likelihood of dissipating the impact of pretrial publicity and emphasizes the elements of the jurors' oaths. I'm not sure I really understand this or agree with it. I don't understand how sequestering jurors would enhance the likelihood of dissipating the impact of pretrial publicity. If I'm threatened with months away from my family in some crappy hotel with bad food while I decide this case, am I going to be more likely to say, I don't remember anything about the case, or am I going to tell you absolutely everything I know about it and tell you how much it's affected me so I don't have to go through that? I don't understand the reasoning on this one. But anyway, this court has outlined other measures short of prior restraints on publication tending to blunt the impact of pretrial publicity. Professional studies have filled out these suggestions, recommending that trial courts in appropriate cases limit what the contending lawyers, the police, and witnesses may say to anyone. We have noted earlier that pretrial publicity, even if pervasive and concentrated, cannot be regarded as leading automatically and in every kind of criminal case to an unfair trial. The decided cases cannot be made to stand for the proposition that juror exposure to information about a state defendant's prior convictions or to news accounts of the crime with which he is charged alone presumptively deprives the defendant of due process. It matters what the publicity is about, doesn't it? And we're not in a position to know that right now. Very early stage of the case, we don't know what has come out in subsequent investigation. The court's in a position to be able to know that and to consider that in order to decide, hey, would it be really bad if, for example, this particular investigative fact that's been developed came out? You can do that in a closed hearing. You can do that in camera. You know? But to just assume ahead of time, well, there will be more and it will be bad. I don't see that. I just don't see that. If a witness wants to speak and wants to advocate for a particular position, I don't know that that's really all that detrimental. I really don't. In Koberger, we saw the Gonsalves family in particular spoke out all the time and were not remotely hesitant about expressing their opinion. Was that prejudicial? I really don't know that it was, because everybody knows you have an interest. Everybody is going to be able to evaluate what you have to say with that in mind. If Tyler Robinson's family, for example, were to speak out, we would all know that relationship, and that would be something we would account for in deciding, well, how much weight are we going to give this? How much influence is it really going to have on my own thought process? So it just really seems like it depends on what could come out, because there's already quite a bit out there, and there is going to be more because there's going to be a preliminary hearing. So what outside of that poses such a big threat? That's what the court should need to decide. And it should have to evaluate, and it should have to have some evidence to base that on. But it doesn't do any of that because it just knee jerk. Oh, got a high profile case, better sign a gag order. Appellate evaluations as to the impact of publicity take into account what other measures were used to mitigate the adverse effects of publicity. The more difficult prospective or predictive assessment that a trial judge must make also calls for a judgment as to whether other precautionary steps will suffice. We have therefore examined this record to determine the probable efficacy of the measures short of prior restraint on the press and speech. There is no finding that alternative measures would not have protected Simmons's rights, and the Nebraska Supreme Court did no more than imply that such measures might not be adequate. Moreover, the record is lacking in evidence to support such a finding. We're in the same place with this order. It's completely silent on these other measures won't be effective, let alone why. Finally, my favorite part, we must also assess the probable efficacy of prior restraint on publication as a workable method of protecting Simmons's right to a fair trial. And we cannot ignore the reality of the problems of managing and enforcing pretrial restraining orders. Yeah, big problem. The territorial jurisdiction of the issuing court is limited by concepts of sovereignty. Indeed, you can't shut up people in other jurisdictions. You're going to find it very, very difficult to do that. The need for in personam jurisdiction also presents an obstacle to a restraining order that applies to publication at large, as distinguished from restraining publication within a given jurisdiction. The Nebraska Supreme Court narrowed the scope of the restrictive order, and its opinion reflects awareness of the tensions between the need to protect the accused as fully as possible and the need to restrict publication as little as possible. The dilemma posed underscores how difficult it is for trial judges to predict what information will, in fact, undermine the impartiality of jurors, and the difficulty of drafting an order that will effectively keep prejudicial information from prospective jurors. When a restrictive order is sought, a court can anticipate only part of what will develop that may injure the accused, but information not so obviously prejudicial may emerge, and what may properly be published in these gray zone circumstances may not violate the restrictive order and yet be prejudicial. That's part of the problem. If you don't know what could they come up with, then you just you don't know. You don't know what the harm could be. There could be people that have extremely damaging information that aren't witnesses and will never be witnesses. And that's, from my perspective, as the defense attorney, that's one of the things that is probably the most prejudicial that gets out there. Is as soon as somebody's arrested, they go and do all the bad guy interviews, right? Let's go find somebody from his kindergarten class who will tell us about how he was so mean on the playground. He's got a terrible character. That's never going to be something that comes out in court. But those are the types of things that fix the audience's perspective on this individual and their character, and based on their character, their propensity to commit a crime like this. So is this order even going to reach the people that it needs to reach? To preserve the right to a fair trial, to keep the jury open-minded? Finally, we note that the events disclosed by the record took place in a community of 850 people. It is reasonable to assume that without any news accounts being printed or broadcast, rumors would travel swiftly by word of mouth. We have social media today, so even without news accounts printed or broadcast, we have social media. We have a lot of spread of information by social media and a lot of spread of misinformation by social media. One can only speculate on the accuracy of such reports given the generative propensities of rumors. They could well be more damaging than reasonably accurate news accounts. Exactly. But plainly, a whole community cannot be restrained from discussing a subject intimately affecting life within it. Given these practical problems, it is far from clear that prior restraint on publication would have protected Simmons's rights. And frankly, it's far from clear that it would protect anybody's rights. It's very difficult to see how an order shutting people up is the solution here when you can't enforce it and you can't subject some of the most damaging information to it. Finally, another feature of this case leads us to conclude that the restrictive order entered here is not supportable. At the outset, the county court entered a very broad restrictive order, the terms of which are not before us. It then held a preliminary hearing open to the public and the press. There was testimony concerning at least 2 incriminating statements made by Simmons to private persons. The statement, evidently a confession that he gave to law enforcement officials, was also introduced. The state district court's later order was entered after this public hearing and, as modified by the Nebraska Supreme Court, enjoined reporting of confessions or admissions, any other information strongly implicative of the accused. To the extent that this order prohibited the reporting of evidence adduced at the open preliminary hearing, it plainly violated settled principles. There is nothing that prescribes the press from reporting events that transpire in the courtroom. So this is a little bit, distinct from what we're dealing with in our particular case. We're not talking about a closure of the court or a prohibition against publishing stuff that has been presented in open court. We're talking about preventing people from being able to say things outside of court in the first place. So, to the extent that gag orders are now kind of everywhere and routine, they don't seem to be gag orders on the press. They're not. They figured out that that's a problem. Okay, that's a bridge too far. That one's a little too hard to justify. So instead, they just restrain the trial participants. So finally, the record demonstrates, as the Nebraska court held, that there was indeed a risk that pretrial news accounts, true or false, would have some adverse impact on the attitudes of those who might be called as jurors. But on the record now before us, it is not clear that further publicity, unchecked, would so distort the views of potential jurors that 12 could not be found who would, under proper instructions, fulfill their sworn duty to render a just verdict exclusively on the evidence presented in open court. We cannot say on this record that alternatives to a prior restraint on petitioners would not have sufficiently mitigated the adverse effects of pretrial publicity so as to make prior restraint unnecessary. Nor can we conclude that the restraining order actually entered would serve its intended purpose. Reasonable minds can have few doubts about the gravity of the evil pretrial publicity can work, but the probability that it would do so here was not demonstrated with the degree of certainty our cases on prior restraint require. Of necessity, our holding is confined to the record before us, but our conclusion is not simply a result of assessing the adequacy of the showing made in this case. It results in part from the problems inherent in meeting the heavy burden of demonstrating in advance of trial that without prior restraint, a fair trial will be denied. The practical problems of managing and enforcing restrictive orders will always be present. In this sense, the record now before us is illustrative rather than exceptional. It is significant that when this court has reversed a state conviction because of prejudicial publicity, it has carefully noted that some course of action short of a prior restraint would have made a critical difference. However difficult it may be, we need not rule out the possibility of showing the kind of threat to fair trial rights that would possess the requisite degree of certainty to justify restraint. This court has frequently denied that First Amendment rights are absolute and has consistently rejected the proposition that a prior restraint can never be employed. So they're cautioning, hey, seems like an inherent problem, but we're not going to say there's no set of circumstances where a prior restraint would be justified. That should emphasize the rarity that these orders should have. They should be so extremely rare. Okay, unique circumstances where you have a severe threat justifying prior restraint. Our analysis ends as it began, with a confrontation between prior restraint imposed to protect one vital constitutional guarantee and the explicit command of another that the freedom to speak and publish shall not be abridged. We reaffirm that the guarantees of freedom of expression are not an absolute prohibition under all circumstances, but the barriers to prior restraint remain high, and the presumption against its use continues intact. We hold that with respect to the order entered in this case prohibiting reporting or commentary on judicial proceedings held in public, the barriers have not been overcome. To the extent that this order restrained publication of such material, it is clearly invalid. To the extent that it prohibited publication based on information gained from other sources, we conclude that the heavy burden imposed as a condition to securing a prior restraint was not met, and the judgment of the Nebraska Supreme Court is therefore reversed. Nebraska Press, guys. 1976. And that is the last time that the U.S. Supreme Court has addressed the issue of when a court can gag anybody from talking about cases. So what's happened in the intervening almost 50 years? What has happened? Like I said, courts have figured out little workarounds, and other courts have figured out here's ways that we can distinguish Nebraska Press from the circumstances that we're facing and what we want to be able to do. And so the first area of departure is that these gag orders now no longer apply to the press, right? They don't order the press not to publish information. They just order witnesses and investigators and lawyers and everybody not to provide it to the press in the first place. So as a result of that, there is now a circuit split, actually a three-way circuit split on what the standard is to impose a gag order on trial participants. If you're interested in knowing more about this, I'm just going to point you, I'm not going to go through this. I'm not going to go through this case, but I will just point out, because many of you are following Aaron Spencer over in Arkansas. This is the case of the guy who his daughter had been groomed by a known offender, and the offender had been charged with child crimes, but was released on bond. And then while on release, went and kidnapped the daughter from her home. The father chased them down and ultimately ended up shooting the offender, recovering his daughter, and is now being criminally charged with murder by the state of Arkansas. So it's a self-defense case. State didn't seem to be all that interested in the safety of his daughter, so he took it into his own hands. Anyway, that was a case where there was a gag order put into place, and the gag order went up to the Arkansas Supreme Court. And so there's a lot of this same information that we've talked about in the Arkansas Supreme Court's decision. But one of the things that they point out, this is from earlier this year, okay, 2005. There is still this three-way circuit split. Let me find it real quick. I think I scrolled past it. Three-way circuit split about what standard applies, because some courts have basically decided, well, Nebraska Press, that only deals with the standard that you have to apply when it's the press itself that is being gagged. And so that will require this clear and present danger standard. But trial participants, people like witnesses and lawyers and stuff like that, there's case law like from Gentile that suggests they can be regulated under kind of a lower standard. And so we won't require a clear and present danger in those types of orders. We'll require some kind of lesser standard. I can't find where it is in Spencer, but it is. They talk about it in there. So basically what you have is you have 4 circuits, the 6th, the 7th, the 9th, and the DC circuit, that say any kind of gag order on trial participants has to be a clear and present danger to a fair trial. That's the standard. There has to be evidence to support that. The Third Circuit and the Fifth Circuit say, well, it just has to be a substantial likelihood of material prejudice. So a little bit more than more likely than not, right? It has to be a substantial likelihood and material prejudice, kind of in the middle. And then you have the Fourth and the 10th Circuits that say just a reasonable likelihood. That's all, just a reasonable likelihood that a fair trial will be jeopardized. Very low bar, very low bar. Utah, guys, is in the 10th Circuit. So Utah is subject to this very low standard. Why I bring this up is because this circuit split has been out there for, I mean, at least 25 years. I first found a case that was recognizing it, that was a district court case from back in the early 2000s, acknowledging there is this circuit split. Circuit splits are the kind of thing that position a case to go up to the U.S. Supreme Court. It's one of the considerations they'll have, since they take so few cases. Their review is discretionary. They don't have to take a case, so they prioritize which ones they're going to take or not. And cases that will resolve a split in authority between different circuits, very high priority, because you need to have uniform interpretation of something like the constitutional law that's supposed to apply to everybody. So when you have this extremely difficult standard in some circuits and this extremely permissive standard in other circuits, it's really not clear. And then those other courts, like state courts that are looking to the federal courts to try to interpret what are we supposed to do, knowing that our decisions about the U.S. Constitution can ultimately be reviewed up through these federal courts. What are we supposed to be doing here? It's kind of all over the place. We don't necessarily know what the standard is. So it's the type of issue that's positioned well for review by the U.S. Supreme Court. The fact that we're in Utah here too means, okay, we're subject to this very low standard. And so that means the court is more likely to uphold a gag order than in a situation where the standard is more stringent. So we're in a position to potentially be able to be aggrieved by the rulings, to take this decision all the way up, so that the U.S. Supreme Court could, for the first time in almost 50 years, address gagging people. You said in Nebraska press 50 years ago, this was extraordinary and required this extensive factual record. And yet now it's just become this thing that courts routinely do without any kind of evidence, on their own motion, with minimal findings. It's just rote. Is that okay? Is that okay? Normally, folks who are strong advocates for the First Amendment, like, historically, the press, would be all over that. They would be all over that. And so it just remains so bizarre to me, the silence in this particular case, the lack of challenge to this particular gag order that is so high profile. It involves political issues, okay? Political speech is like at the core of the First Amendment. That's what it's supposed to be about. There are going to be all kinds of questions about the investigation and the process, how it's handled. Questioning our government and how it works is at the core of the First Amendment. And so I'm just so perplexed. I'm so perplexed. We have this gag order that on its face does not meet the standard of Nebraska Press Association. In a jurisdiction where the courts just decided we're going to apply a lower standard because we don't think it's the same. And you're positioned to get clarity for the entire country about, is this routine practice now? Is that consistent with the principles we have in the law? and they're not doing it. And I just don't get it. I really don't. I really don't. I just find it really bizarre. Am I putting too much faith in the modern news media? I mean, they did it in Coburger, right? They came and challenged the gag order in Coburger. They just got outmaneuvered by Judge Judge. Judge Judge, he was so clever. He was so good at getting people to negotiate something that they could live with there on the bench. And then once you've negotiated, yes, I can live with it. Well, then you can't challenge it anymore because you've invited the error. You've bought in. You bought in. It's a very, very clever judge that way. But not even a challenge on this one, over a month. I'm not quite sure what to make of that. One thing I do make of the order, the fact that the order is out there, it means question any information that you get, question the information environment. If we assume that the lawyers in the case don't want to be found in contempt, we can assume that they've passed this order along like they've been told that they have to do. Don't know if it's a real fair assumption that trial participants wouldn't necessarily want to jeopardize the trial or their own participation by speaking out. But what this ultimately does, it gives us the same situation we had in Coburger, where there's going to be anonymous sourcing of information that may or may not ultimately end up to be correct at all, because there's no way to vet it, because the people who are in positions of prominence, recognition, authority, knowledge in the case aren't going to be able to speak out to correct misinformation. So it's a big problem. This is one of the biggest drawbacks from my perspective, the unanticipated negative consequence of having a gag order is you create a vacuum for misinformation to come in and fill the void and to feed the appetite for information about the case. And you take away the ability of those who have the power and the knowledge to correct the misinformation. You take away their ability to do that. How is that furthering a fair trial? So guys, that's pretty much all I had to say today about the case and about the gag order. Yeah. I suppose football is going on by now, so I don't blame you at all if that's calling your name. I suppose I'm gonna have to check some of it out myself, but yeah, I just I don't know why the press seems so disinterested in retaining the historic mantle they always had of the advocates of the First Amendment and the public's rights, freedom of information, and all that type of thing. Seem to be abdicating that here. Of course, now that I'm done, the kitties are finally snoozing away. So let's see what you guys have had to say. Cindy Collins is a new member. Welcome, Cindy. Welcome to the channel. Appreciate having you here. James Casatelli, I love the new cat era. Well, it is definitely a new era. Still getting used to it. Here's big old Jude. Look at these long cats. Look how long they are. They're fun and they're very sweet, but they don't sleep nearly as much as they used to. I was told that cats sleep like all the time. I am not finding that to be the case. They don't actually sleep all that much. Hi, sweetie. Yes, a sweet kitty. Kim Neighbor. Off topic, I know, but I'd love to throw the Raul Valle case and retrial into the ring for your coverage. It touches on legal issues around immunity deals and selective prosecution. I am interested in the power and privilege at play. I will write that down, Kim Neighbor. Raul Valle case, immunity, and selective prosecution. Let me take a look at it, and I'll get back to you. Yeah. Keep an eye on my Substack. I will say that a lot of times, if it's just like if I've got like a one-off take on a case or something like that, it's not ongoing or it's maybe not something I'm going to be following in depth. I'll write about it instead of doing a live stream. So do keep your eyes open there. Because it could very well be, if I find something about it, I might find something that is compelling to write about. If it's not something that I think is gonna, maybe suit this particular format, but I will absolutely take a look into that. Thank you for bringing that up. I do always like case suggestions, guys. I'm not, always going to follow everything, but I'm happy to take a look and see if it's something that looks like the kind of case I'd like to follow. Linda LW is a new member. Welcome to the channel, Linda. Dawn Zuger, I disapprove of gag orders for the record. Yeah, I generally do too. I don't like being told to shut up. Okay. I don't like being told to shut up. It doesn't sit well. It's just not consistent with the American way. We were founded on the marketplace of ideas, and that if you have to shut somebody up, it probably means that they have a pretty good idea. Because if you can't counter it with your own ideas, then that's what you have to resort to is shut it up. This is why I tend to have a pretty free speech kind of approach to the chat here and my own channel. It's not that there's no rules. We don't like assholes here. It's pretty much the rule. If you're going to be an asshole and you're going to, not fruitfully and in good faith contribute to a conversation, then you don't need to be here. But you can say stuff elsewhere. You can say whatever you want about me on other platforms. Feel free to do that. But it's just it's a tell. It really is. It's a tell. If you have to tell people to shut up, it means you're afraid of the impact of what they have to say. And if you're afraid of the impact, kind of tends to suggest it's because you don't have a good counter argument. So you either need to get smarter, or you need to maybe question your own predicates. Torin 3, I got the fish braided today. Should have the first kitten braided on Tuesday's stream. I sent a pic to Jeff. I can't wait to check that out. Yeah, I'll check out the stream on Tuesday. So I'm still locked out of X, guys. It's still hijacked. X seems to not care at all. I've reported it. Folks, I asked folks, if you are so inclined and don't mind, please go ahead and report the account at this point, because if I can't get it back, then we might as well just try to nuke it and limit the damage that it can do. So it's kind of a mixed bag, because on the one hand, Twitter is an absolute cesspool, and I waste so much time scrolling. I can't believe how much more time and productivity I have not scrolling through X. But on the other hand, it has been a kind of meeting point for me for all kinds of different people and different things going on and stuff like that. And so I have kind of lost contact with some folks that contacted me through X. So I am still on Instagram. I don't do a whole lot there. There are cats there if you're interested in that type of thing. I'm putting the cats on Instagram, and I tend to put travel pictures and things like that on Instagram. But otherwise, I don't know how X people can get in contact with me. just continue to keep my fingers crossed that maybe X will take an interest, but can't say I'm really holding my breath at this point. But thank you for sending the picture to Jeff. I will definitely check it out. I can't wait to see it, and I will take a look at the stream as well. So, guys, that's it for today. Still got plenty of time for plenty of football. Go Birds. We'll see. Not necessarily having the rock star season we had last year, but a lot of football still left to play. We have a nice cool fall day outside today, so leaves are starting to turn. We're almost at the point where it's time to put the bonsais to sleep. Not quite yet, but getting pretty close. Gonna have a lot of leaves to rake and all those other things. Oh, hi, Gus. You want to come up and say hi? Well, you're gonna be saying bye now at this point, so maybe you purr. Yeah, I don't know if anyone can hear that, but he's a little purr ball, this Gus. So anyway, the cats almost fit the harness now too, so we're just about ready to be able to introduce them to the great outdoors. Look at how fierce you are. My goodness. Just all this, non-screen life stuff that is available out there for all of us to go and enjoy. So I do plan to get some of that in. And in the meantime, hopefully not get myself chewed and clawed into bits. But I guess we all kind of know who the boss is at this point. So yes, sweetie. All right, off you go. Hey, everyone. Thanks for joining me. Appreciate your interest in this topic. It is one that I think is important. It is one that just desperately needs some revisiting by the court. I would love to see the folks who are conventionally the ones who vindicate our rights in these kinds of areas take more of an interest in it. Maybe they will. We'll see. So until then, guys, I will see you next time. So here's what I have kind of tentatively planned. I do want to do another stream before the hearing on the 30th, which I am planning to live stream to, by the way, and that's going to be at 10 Mountain Time, which is 9 Eastern for me. So that's on Thursday, the 30th, in a couple weeks from now. But in the meantime, the other filing that has come up that I would like to be able to go ahead and go over with you guys is the filing about shackling and plainclothes. The defense is moving that he be allowed to attend all of his pretrial proceedings, not just in civilian clothing, but also unshackled. And so that's been filed. There's been a briefing schedule that the court has set to kind of accelerate that so that they can have a decision before we have this hearing on the 30th. And then we will know when he shows up on the 30th, well, what's he going to be wearing and is he going to be shackled? So that one is, I think, it's kind of interesting. Again, it gets into these issues of what's prejudicial. Okay, we're gonna gag people who might speak on his behalf, but we're gonna parade him in front of the cameras in the turtle suit with his stun belt and stuff like that. I mean, it just sometimes comes across as a little bit of a double standard, a little bit of a talking out of both sides of our mouths when it comes to the when it comes to the fair trial stuff. So anyway, it's an interesting issue. Courts routinely just do what law enforcement wants them to do as far as courtroom security. But the defendant has found some case law that is pretty persuasive on the argument that the court can't just delegate that decision to law enforcement. They have to make it themselves based on the needs of the case. And it's also a pretty good first glimpse at the quality of the legal advocacy in this case for the defense. I said the last time, these guys are legit. Okay, these guys are legit. These are legit lawyers, and their writing, it's extremely good. It's very, very good. Um, so we've already got the defense motion, but I do want to wait until the state files their response, just so that we have, we got both sides of the issue, and we also have kind of the stylistic counterpoints to be able to examine as well. So that's what I have coming up in the short term. Do keep your notifications on if you're interested in finding out when that will be, because I don't know exactly what the date will be yet. I got a whole bunch of stuff going on next week, so I will just find a time when I'm free, and we'll get it done. So with that, guys, thank you for sharing your football Sunday with me, at least a little bit of it. There is still some left. So do go out and enjoy the rest of your weekends, and I will plan on seeing you guys next time. Take care, everybody.